Dear friends, in my previous video about pension, I told you that the legitimate expectation of the retired employees is pension and other related benefits. But most of the employers, DDOs, we can say, drawing and disbursing officers who are responsible to submit all these records to the higher authority for clearance of the benefits, they are not doing properly. The only reason which I have indicated there in my previous video is this, that there is no question of any punishment at all, no accountability on the part of the employers, DDOs. The concerned officers will resort to such type of harassment and torture, killing the time without sanctioning the retirement benefits to the retired persons because of that only. No punishment. But here, for the first time, Jharkhand High Court had decided in a very sterling fashion. Here, in this case, the present case, that is Santhilal Singh versus State of Jharkhand, 2026 March. That means the last week of March 2026, a very sterling decision, a sensational judgment was pronounced. And there, the court said that imposed punishment to the officers who are held responsible in this case. Here, the case is one clerk. After a long service, he has taken a superannuation. After retirement, he retired in the month of March 2011. Even after a long time, so 5, 6, 7 years, his pension was not clear. And the ground of the officers is this: his SR is not traceable, and some other related records are also not traceable. Because of that, his pension and other benefits have not been clear. This is the ground of the officers. He was an employee in the district transport office. He approached the court. The court issued some relief, but it was not carried out, not implemented. Again, he applied. Again, he submitted the petition, and that petition is contempt the court against the district transport officer. And they were taken to task, and finally, the judgment was like this. See, if the records, that means the service records or related records, are not available, not traceable, whose is the fault? It is the fault on the part of the officers, the drawing officers, not the employee. His duty is to work and get the wages. That's all. So better you must sort out all the things clear. I don't know how you will get the SR, how you will get the related records. Go and search and clear all the benefits, retirement benefits, within 6 weeks' time, 1.5 months' time. Otherwise, the first thing is the concerned authority or officer, that is a district transport officer's salary must be withheld. So hold the salary. Also the commissioner who is responsible for that. That is two. And the third one is this decision, court decision must be circulated, issued to all officers like chief secretary to the government. The second one is commissioner of the department, and third one is AG. That means accountant general. So very, very sensational for the first time in the history. I have not seen such a terrific decision pronounced by the court. For the first time, Jharkhand High Court, as has been expected, issue this kind of judgment, punishment to the officers responsible. And in the second case, another case, three cases I would like to tell you here. The second case, there is the State of Jharkhand, same High Court of Jharkhand versus Brajeswar Singh, March 2026. In this case, in the same way, more or less the similar aspect here. That is, the employee's behavior was not is said to be alleged, said to be something wrong, not proper, improper behavior, misconduct. Another one is irregular in his duties. On the basis of this, his pension and other benefits were stopped, pending, kept pending. Very surprising thing is the allegations were not proved. They must be proved, but not proved. And what the court said here, let us see. See, if the employee behavior misbehavior, if the employee has misbehavior, or if he suppose he was irregular, what to do? You must have conducted the departmental proceedings, inquiry, everything, and in the departmental proceedings, you must have taken some decision by now. Already by the time he retired, but even after retirement, you keep everything in suspense. You keep everything pending, everything pending. And now you say, oh yes, this is so many complaints against him, misbehavior and irregularity and all that. No, that is not the ground. Okay, in the department proceedings, you say that there is misbehavior or irregularity. Now, come on, show me the departmental proceedings. There must be departmental proceedings showing all the details and the action taken against you. Here, the allegations were not proved. That is the point to be noted. Allegations were not proved, baseless. That means some personal revenge or the other, we don't know. So it is the responsibility of the officer to have conducted all the inquiry, issued the departmental proceedings or everything by the time he retired. But we have not taken. So clear. And their decision, the department decision is okay, we will give, but 15% deduction on pension every month until the completion of 5 years. So for 5 years, 15% deduction on pension will be there, said. Even that is also rejected by the High Court. That's the second case. And now the third case, another case, in Bombay High Court. Here, Kiran Rajeswar, Kiran Rajeswar Ram versus Employees Provident Fund Organization and others, March 2026. So in this case, the employee was a pharmacist, worked for a long time, and after that he retired from service. His pension is also withheld, not granted clearly or immediately. And after some his pension was granted, but there is a problem of enhancement of pension, some revised scales or PRC, pay revision, etc. But his pension is not at all enhanced on the ground that on the same ground, missing records and chalanas. So regarding the payment or contribution of the employee to the government, there must be chalanas. Chalanas are not available, and some records were missing. So on these two grounds, his pension enhancement is not done at all. And what is the court judgment? We shall see. The court says that the employer's responsibility is to keep the records safe, just like in the first case, SR. Yes, it is the duty of the employer, DTO, to keep the SR in safe condition. He has to preserve it. Here also, Bombay High Court said the same thing, that it is the employer's duty to preserve all the records, chalanas, missing records, SR, everything for that matter. So, because of your fault, that means officer's fault, why should the employee, this pharmacist, should be penalized and his family should be punished? Why? So, pension is not a favor, it is a welfare measure. According to Supreme Court decisions, it is the property of the retired employee and his family. No favor at all. So, lapse in the maintenance of records is not the duty of the. It is a lapse in records means it is the fault of the employer. It is the fault of the DDO, the drawing and disbursement officer. So that is not an excuse. Lapse in records is not at all an excuse, because maintenance of records and everything is not the duty of the employee. So clear all the benefits. Here also they have given a very terrific decision, but Jharkhand High Court decision is highly sensational and historical also. For the first time, they have given punishment to the officers who are responsible for stoppage of the pension of the retired person and his family. This is about pension and the difficulties that the retired persons are facing after retirement, irrespective of the clearance of the benefits. Thank you very much.